Okay, so I'd like to welcome everyone here today for our presentation on intellectual property. As most of you know, my name is Allison Rowe. I'm the manager with the Navigate Entrepreneurship Program. I'm just going to give you a very brief introduction to Navigate before handing it over to Cara Strickland. So Navigate is a partnership between Graphical campus and College of the North Atlantic campus in Corner Brook. And we help entrepreneurs and entrepreneurs from the very early startup stage on through to prototype and product development, and then to commercialization, implementation, and launch of their business. So as you may know, we have three different services. There's the Entrepreneurship Center, and that's for the very early stage, the ideation and business planning stage of entrepreneurship. And those are located both at the Graphical and CNA campuses. We also have a makerspace, and that's for the prototype and product development piece that I was talking about. And that's located at Graphical campus. And then we have a business incubator for companies that have reached commercialization. And we have a co-working space there as well, and that is located on the CNA campus. As many of you know, at the moment, our offices are physically closed, but we're still serving people remotely. At the end of the presentation, I'll put up my contact information for anyone who wants to reach out. So today we're going to be talking about intellectual property, what it is and why it's important. And some of the subjects that we'll be touching on are copyright, trade secrets, patents, trademarks, including branding, important considerations for commercialization, and also the MUN Technology Transfer and Commercialization Office, and what their role is and how they can support you. If anyone has any questions throughout the presentation, just put them over in the chat section, and Cara will be happy to answer those. So our wonderful presenter here today is Cara Strickland. She is an intellectual property officer with the MUN TTCO, and she helps people who have IP map out their path towards commercialization, and she's able to answer any of the questions that you have about that. It's a really valuable service that they offer. The intricacies of intellectual property are many, and it's a complex thing to navigate. So Cara is there to help you along the way. So without further ado, I'm going to introduce Cara, and I'll get her to share her presentation here.
Thank you, Allison.
Okay, and I'm going to hand it over to you.
Just let me know that you can see the screen there.
Yeah, all good.
Okay, perfect. So again, thank you, Allison, for having me here today. And like Allison mentioned, I'm with Memorial's Technology Transfer and Commercialization Office. And our office supports faculty, students, and staff at Memorial in figuring out what the steps are to commercialize the intellectual property. In saying that, we also assist with, if there are questions that come from Navigate, we help from Genesis and at St. John's, and also Memorial Center for Entrepreneurship as well. So we support helping move ideas to opportunities. So with technology transfer, it is the process of moving ideas toward opportunities and making sure that it can benefit society. So at MUN, through the Tech Transfer Office, there are so many different things that we can do to do that. So we support the development of IP. So at those very early stages when people have ideas, we can work with them to help bring their research to life. We also provide education on intellectual property, like I'm doing here today, and helping people understand what their intellectual property rights are, especially from a memorial perspective, like whether or not somebody owns the intellectual property, we help sort out those details. And then we assist with commercializing the outcomes of research. So if somebody's looking for a collaboration between the university and a company, we're here to support that. We also help with licensing intellectual property. So if someone wants to license IP from the university, we can help with that, and also supporting spin-outs starting from projects that are within the university. So I've mentioned a few times intellectual property without actually saying what it is. And this is actually the definition from the World Intellectual Property Organization. It's quite a complicated definition, so I'm not going to read that. But to put it a little bit more simply, intellectual property is an intangible creation of the mind. So an idea that you can express or translate into a tangible form that can then be protected. It is really, really important to understand what your IP is, what you should do with your IP, what the next steps are if you're planning to use intellectual property into a company. And by improving your understanding of intellectual property, it will mean that you'll be able to identify it early on so that you understand what it takes to move your idea towards success. So IP within your company is often your most valuable asset. So by understanding what it is, you're then able to protect it at the very early stages. And as we go through this presentation, you'll see why it's important to understand very early on what it is, because in a lot of cases, you can't get protection after the fact for certain types of intellectual property. So we're going to cover quite a bit today, but at any point, feel free to put questions in the chat, or you can use your mic too if that works and ask them to me. The other thing is as well, if you don't want to talk within this presentation, we can also arrange to have a meeting afterwards to talk about what your intellectual property is and what types of protection are available. I will let you know that I'm not a lawyer, and I will send people for legal advice to other areas when they require it. But as Allison mentioned, I work within the university, helping with that commercialization aspect and understanding what the IP is so we can make those next right steps. So just to get started, the first type that we're going to talk about is copyright. A lot of people recognize copyright with a little C around it. It's one that most people are probably most familiar with. But copyright protects expression of an idea. So it's not the actual idea itself, but instead it's it's actual work. So it's things like writing, music, works of fine arts, but it protects that specific piece of work, not the idea of it. So as an example, you can't protect the plot of a story, but you can protect the actual written work that you've created. So to secure a copyright, it's actually automatic as soon as the work is tangible, but you can register it. And by registering, it costs between $50 and $65, and then it provides you with a certificate that you can use as evidence in court that you own that protected work. All you have to do is just identify what you're copywriting. And copyrights go for 50 years after the year in which you die. If for some reason I died sometime within this 2020, then my copyright would be good until December 2070. I'm just going to provide a random example of infringement. This is an infringement case that happened a few years ago. And you'll notice at the top that there is a picture of Mike Tyson. And Mike Tyson has a tattoo on his face. This tattoo is considered a work of art that was created by a tattoo artist named S. Victor Whitmill. When Hangover 2 was coming out, Stu in the movie ended up having this tattoo that was a tribute to Mike Tyson on his face after a night of debauchery. Anyway, right before the movie was going to come out, the movie was actually held up because S. Victor Whitmill said that, you know, this was an infringement on his copyright because they were using his work of art without actually getting permission to do so. So, and the judge actually agreed that this is actually an infringement. So they were utilizing it without the holder of that copyright's permission. So there are a lot of considerations when it comes to copyright. One of them is computer programs. So computer programs are protected by copyright because it's considered a literary work. It's consisting of text. So you can't make copies of the software or take substantial pieces of the software and utilize it without permission. Another one that you may be more familiar with is Creative Commons. And Creative Commons is a public license that enables the free distribution of what will be copywritten work. So in order to utilize it, you have a license for that. So they're giving you a Creative Commons license, and it may have some restrictions on there. So it may say that you have to credit the photographer if you use a specific picture. So one important thing, if you're using Creative Commons work, is to read what that license says to see if there are any restrictions to how you use it. Similarly, if you're using something that's open source, again, open source code has a license that's associated with it. So it's really important that you read what that license says and that you understand how you're allowed to use, study, modify, or distribute anything that's utilizing that open source piece that was made available. So as a company, there are a lot of considerations when it comes to copyright. One of the most important things is whether or not you own the copyright that you want to use in your company. So as an example, if you want to use a photograph on your website, do you have permission to use that photograph? If you don't, you need to figure out how to get permission to utilize it. Or if you get it from a website that provides them for free, is there a license to utilize that picture? And make sure that you do that so that you're not infringing, so that you're not going to get a cease and desist letter or get sued for infringing on copyright. So another thing to consider is that for your employees, do you have an employment agreement in place? Because again, you want to make sure that there is an employment agreement so that you will end up owning the copyright that's associated with it. So if they're doing work for you, that you own that piece of work, or your company owns that piece of work rather than the individual. Because like I said earlier, copyright is automatic. So if I create something and it's not under my employment, I own it. But if I create it under my employment, then of course my employer then owns it unless you have a different agreement. So the next type of intellectual property that I'm going to talk about today is trade secret. So trade secret is just a really broad term that's defined by how you treat or protect intellectual property. So trade secret can be any valuable business information that you have that derives its value from secrecy. So when I say derives its value, you get the competitive advantage from the secrecy of that. So it can include so many different things. It can be, your research and development information, your software algorithms that you've created. It could be an invention you've created, but you haven't released it yet. It could be ingredients for a secret recipe that you have, or a method that you have. Essentially, it's confidential business information that you are going to get your competitive advantage from. So there are lots of reasons why you might decide to go this route rather than having your intellectual property fall under one of the other categories. So first of all, you might decide that you're going to keep it a secret because you haven't applied for a patent or industrial design. So as we talk about patents and industrial designs later, you'll find out that there's a requirement for it to be novel. So you can't release it before applying in most jurisdictions. So because of this, you might decide that you're going to keep it a secret until you've applied for it. Another reason is that you might decide that your invention has a short lifespan or is difficult to reverse engineer. Patenting can take quite a bit of time. It can take sometimes up to 5 years to get a patent. So you might decide that, you know what, I'm only going to be selling this for a year, and it's really easy to reverse engineer, it's very, very difficult to reverse engineer. So I'm not going to get a patent. Instead, I'm going to keep it a trade secret. So that would be another case. Another might be you can't protect it through other intellectual property rights, or maybe at this point in time, you're still making a lot of modifications to a product, so you haven't finalized your design. So you might decide that right now that you're not going to release it, so you're going to keep it a trade secret. So there are many examples of excellent trade secrets that have been very successful in gaining commercial advantage. So as an example, Coca-Cola's formula has been guarded for over 100 years. They have a secret recipe that essentially they get their commercial advantage from. Now, there was a case back in 2006 where an employee and 2 accomplices stole the formula and tried to sell it to Pepsi. However, Pepsi let Coca-Cola know, and the employee and his accomplices were arrested and charged because they stole a trade secret from a company. Another great example is Google's search algorithm. So Google does release some general information about how their search engine works. However, they don't provide the specifics on it because they don't want anybody to modify be able to manipulate the system so that they are ranked high on searches. So they only release specific information. Another great example is Kentucky Fried Chicken recipe. So originally, the recipe was just kept in Colonel Sanders' head. Eventually, he wrote it down. He put it in a safe. But right now, only a few select employees know the recipe, and they're bound by confidentiality agreements. So they have agreements in place that state that they aren't allowed to release this. For better protection, there are actually two separate companies that blend the herb and spice mixture, and then it's actually processed to standardize the blending before it's sent to restaurants, so that it's not actually, someone at the local KFC restaurant won't know what the recipe is or the specifics of how that herb and spice mixture is mixed. So there are many different ways that you can keep a trade secret. You can have non-disclosure or confidentiality agreements, and these can be with your employees, they can be with your collaborators, they can be with your manufacturers. In all these cases, you need to consider, how are you going to keep this information from getting out? And without having the right tools in place, somebody might release the information either unknowingly or knowingly. You can have confidentiality clauses in agreements. You might use encryption on your computer so that somebody can't steal the data from your computer. You might have used password protection or a lock and key like Colonel Sanders did. But trade secrets can last forever and as long as you can keep it a secret. So you need to make sure, again, that you have the right tools in place for your company so that information will not be released. And if information is released, that then you have a tool to go and go after those individuals who have released the information. That is trade secret. So the next section is patents. And a lot of people, if you talk about intellectual property, the first thing that comes to mind are patents. And at Memorial, we use patents to help transfer technology to industry and to spur innovation. So if a company is looking to license technology from the university, we need to make sure we have protection on that so that we're able to commercialize it and then gain licensing revenues for it. If we don't have a patent, somebody can just create that technology and duplicate what's already been done. So by having a patent, there's economic value for both the inventors and the university, as well as for the company that's selling the product. So the patent process originated back in the 1500s, and it was created to help drive the advancement of society. So before, people would be working in their basements, not letting anybody know what they're doing, keeping everything a trade secret. But by having the patent process, it means that you can release what you do, and it will ensure that those people who created it will benefit or profit from their inventions. It also provides incentives to create, and it motivates people to improve on technologies and to share the outcomes of what they do. So a patent is a legal document that prevents others from making, using, selling, or importing technologies or products that are claimed in patent areas in which you're protected. It is really important to note where I say like selling or importing technology. So if you create something here in Canada, but someone's manufacturing in China and trying to sell a knockoff here in Canada, it gives you a way to be able to go after them to stop that technology from being imported. However, if you don't have a patent in China, they are able to manufacture it and sell it in China. A patent provides you exclusive rights to your invention for 20 years. So after the time in which you apply for a patent, so you submit an application, if your patent is granted, you will have exclusive rights for 20 years from the date in which you applied for that patent. Patenting is a really important, powerful business tool that can help you, again, reinforce that competitive advantage, because you can use it for financing, so to get financing for your company, as well as to license it. One other really important note here is that if someone does infringe on your patent, like I mentioned before, if someone's selling knockoffs here of your technology, it is up to you to go after the infringer through the court system. So the patent office is not going to do it for you. Instead, it is up to you. So when considering what's patentable, there are certain rules that are in place that have to be met in order to be patented. Anybody can submit a patent application. When people say patent pending, that does not mean that they are going to get that patent. That means that they just have a patent application that's ongoing, but the patent has to be examined to make sure it meets the requirements. So the first requirement is that it has to be novel. So novel means that it's first in the world, one of a kind, not publicly disclosed anywhere in the world. And in saying that, there is a grace period within Canada and the US, but most countries do not allow you to apply for a patent if you've already disclosed it. So if you've already told someone about it, if you've already sold it, you can't apply for a patent after the fact. Just as a kind of a funny example, back in 1949, Donald Duck and his nephews raised a ship, filling it with ping pong balls. However, in the 60s, someone tried to file for a patent on a similar technology where they were using like millions of plastic balls to raise a vessel. In the end, it was rejected because it was in Donald Duck in the Donald Duck cartoon. So again, novelty is very important. The next one is useful. So useful means it has to be functional and operative. So yes, you can file an application for anything, but they will make sure that it's useful and it performs the function and does what it's claimed to do. And that what it does, it has to have some benefit. Finally, it has to be non-obvious. So non-obvious means that it can't be looked at by someone else who's skilled in the art or who has average skill in your field as being the next step. So as an example, if I decide I'm going to make a cleaner and my secret ingredient is vinegar, most people will probably say, you know what, everybody knows that you put vinegar in to clean products. So it may not be considered obvious, or may be considered obvious, sorry. So instead it needs to be like a new combination of features. It has to be something that would be unknown, and something that, you know, gives you new results or gives you a new outcome. So when it comes to patenting, you can patent products, compositions, machines, processes, and any improvements to these. Just as a couple silly examples, the first one here is a recycled cardboard bicycle. An application was submitted for this bicycle. This bicycle weighs 7 kilograms, but can hold someone that's up to 200 kilograms. In the end, this one was not issued. The patent, the inventor decided not to go forward with it. The second one actually was just recently issued, and this is for infectious disease detection by Boeing. Oh, sorry, I skipped ahead there. So with this technology, it actually detects Ebola, tuberculosis, influenza with a number of different sensors. So they applied for this patent, and after the examination process, it was finally decided that the application was going to be issued because it met the requirements for patenting. The patenting process is very long. It can be a very long process, and it can be a very expensive process. We always recommend that you work with a patent agent for it, because the patent agent can make sure that you have the right strategy to go forward with your patent, and that also your patent provides the right level of protection that you need. Your patent needs to be able to withstand court, essentially. Like, they need to be able to show that your patent is unlike any other patent that's out there, and it needs to protect your commercial advantage, and a patent agent can help you with that. Just a couple things to note. After you have an invention, you would normally submit a provisional application, which is kind of like a holding place. And then after a year, you can decide whether or not you just want to file in one country, or if you want to kind of leave it open because you're not sure on what your strategy is and how many countries you're going to want protection in. What this ends up giving you is some more time to figure out what your strategy is. So that after an additional 18 months, then you can decide what countries you'd want to file in. By filing a patent, like I mentioned before, the information will be published. So there will be an international publication of your patent application. But in saying that, you know, if your patent is issued, it will mean that you are protected all the way back. So if somebody else in the countries that you apply for protection in end up filing or end up manufacturing your product, you will be able to go after them for damages. So again, the patents are very expensive. They're around $6,000 to $8,000 for initial filing. When you file your PCT, you normally around another $8,000. There are maintenance fees, and then there are country-specific fees. So in saying all this, it's not to make you not want to get a patent, but instead it's to really have a strategy for it. Because when you start filing in every country, it gets extremely expensive. If you were to file in China, because that's where you're going to manufacture, you would then need to, pay for translation fees, pay for legal advice there, and also a patent agent in China. If you're going to be selling in Canada and the US, similarly, you'd need protection in both those countries as well. And depending on where else you're looking at selling, you may want to expand beyond it. So it is so important to make sure that you have a strategy and you figure out what that strategy is very early on, before you start that real commercialization process. Then quickly, I do want to mention freedom to operate, because even if you have a patent, you might be infringing on somebody else's work. So I use the example of the chair. If I end up creating excellent arms to go on this basic IKEA chair, but it requires IKEA's patent, if it's a patented technology, then I might be, if I go to sell the product, I could be infringing on their product that they have protected. Similarly, you might want to use components that somebody else has created in your product. You need to make sure that you either have a license for that, or that there is no protection in place that would restrict you from going forward. Another really great example of that is with Dolby, like Dolby Digital Sound. You can't use their products with, of course, having a license in place in order to use that. Another thing to consider too is whether or not you can pitch. Can you talk about it? So to patent, it must be novel. So you don't want to be talking about the specifics of how your technology works or provide any enabling information if you plan to get protection for it. So I always say you can always talk about what your value proposition is without talking about the specifics of how your technology works that you plan to protect. Within Memorial, we always work with researchers on this piece of pitching, as well as if they plan to write a manuscript and how they can disclose around the technology. So not actually talking about specifically how it works. The next type of intellectual property is industrial design. So unlike a patent that protects the functionality of a device, an industrial design protects the features or the look of an item. There have been significant changes to industrial design protection since November 2018. So if you are looking up information about it, I do suggest that you go with the Canadian Intellectual Property Office's website, because if you look at other places, the sources may be out of date, and you want to make sure you look at current information. So when it comes to industrial designs, it protects the features of the product that appeal to the eye. So the distinctive looking features like the shape, the pattern, and ornament, or any combination of these that are original and that stand out and kind of make me know, oh, that's that brand, because I can see as soon as I look at it that I know that it's their product. By registering an industrial design, it provides you with a competitive edge that can prevent people from making, using, or selling your product, or even to negotiate a license for your product. And it provides protection for up to 15 years. And in the United States, it's actually considered a design patent. So it's just a slightly different name in Canada than it is in the US. So just some examples of industrial designs and some that you might be familiar with. The first one is the Dyson handheld vacuum. Even though you can't see the Dyson logo on this, when you look at it, you know that it's a Dyson. And that's because of the industrial design. So that industrial design is actually protected. Similarly, if you covered up the Coca-Cola logo or covered up the icons on the iPhone, you would know by looking at it that it is the product, or you would know what brand it is. Another thing to note is that the graphical user interface is also protected. So on the iPhone, the way that the icons are laid out, and also even some of the design features, like if you keep your finger on an icon, it starts to shake so you can move it around. Those are all protected under an industrial design. And in all these cases, the companies would have applied for the industrial design at the very early stages before the product was released in order to maintain that competitive advantage. So the last type of intellectual property I'm going to talk about are trademarks. So a lot of people will think about the TM or R, and they've seen that around. And in Canada, these actually have no legal significance, but there's no real repercussion for using it. But in the United States, if you use the R symbol with a circle around it, so the registered trademark symbol, you can be prevented from future registration of trademarks in that country. So if you're selling to the United States, you need to make sure that you're not using the registered trademark symbol if you haven't registered a trademark in the US. Again, trademarks are specific to each country. So you need to get trademark protection in any of the countries that you require it for your brand. Again, there have been new laws were put in place for trademarks in 2019. So again, look at the most recent information that's on the Canadian Intellectual Property Office website, and be careful about what other sources that you look at. So when it comes to trademarks, it protects the words, sounds, or designs that distinguish a product or service from another. And it does, when you register, it's registered under the Trademarks Act. And if you're not, a trademark registration can actually be canceled if someone else in Canada has already been using that trademark or trade name in the past. So it is really important for, if you decide that you want a trademark, that you search to see what else is in use. Registration for a trademark is good for 10 years, and it's renewable. So you can keep renewing it, every 10 years in order to protect your corporate identity. So there are some rules when it comes to trademarks. First of all, it has to be distinctive. So when I say distinctive, it can't be descriptive. So it can't describe the product that you're protecting. So if I say I'm going to use Apple for a computer, it's not describing the computer. So that would have been considered an eligible trademark name. But if I was using the name Apple to describe a company that sells apples, then it would be much more challenging, or could be much more challenging to get it. The next rule is it has to be non-deceptive. So if you say that it's real leather, but it's actually made of some kind of pleather, then you wouldn't be able to get that. Thirdly, it's supposed to be arbitrary. So using a common word in a meaningless context works. So using Apple for computers, again, as the same example as before, would meet using a common word in a meaningless context. Otherwise, you can use a made-up word like Coca-Cola or Nikon. So just some examples. I'm sorry, someone's snow blowing outside my door, so it might be a bit noisy. So just some examples. Using the Twitter logo will be an example of a trademark. So you'll see here that I can use the logo, and you can use the logo as well on your documentation. But in order to use that, you need to make sure that you go to the brand guidelines and you accept the terms and conditions of it, and that you use it correctly. So if I'm using somebody else's brand, I need to make sure that I follow their guidelines. So with Twitter, they have rules. One of the rules that they have is that the space, or the white space around the logo, has to be equivalent to the distance between the beak and the center of the logo. Similarly, Memorial University has rules like that. Google has rules. The province of Newfoundland and Labrador have rules. All of these, or most organizations have brand guidelines that specify how you're allowed to use it. So if you want to use their logo on your company website, make sure you use it correctly and that you have permission to use it. Another thing that's, one other type of intellectual property I forgot to mention was sound. So like the zoop, zoop of the Star Wars lightsaber is also protected. So it is really, really important that you use trademarks to protect your brand. But before you actually file for a trademark, I would suggest that you use the WIPO Global Brand Database to see if your trademark is in use in the jurisdictions that you that you plan to get protection in. I'm just going to quickly open up the WIPO database. So on the World Intellectual Property Organization database, you can search for text for the title that you plan to use. So whether or not you're going to call your company a specific name that you want to get protection on, you can search and see where in the world that's being used. It's also really important to look at if it's being used elsewhere, just in case you decide to expand there in the future. Then you'd know whether or not it would be a challenge to be able to get protection for that trademark. You can also search by image as well. So you can look to see if there's anything similar to it. And when getting a trademark, they look for confusion in marks. So say, for example, if you use just a slightly different spelling, you likely wouldn't be able to get a trademark on something that's just a slightly different spelling of the same thing. So if you have McDonald's, but instead of spelling it McDonalds, you spell it MAC, and you try to brand that for a burger store, you likely wouldn't be able to get it. So always check to see if your trademark or your potential trademark is being used anywhere else, and do look before you create all your marketing materials, because it can be very, very expensive to make those changes after the fact if for some reason you're infringing on someone else's trademark. I'm just going to pull this back up here. So just as a quick review, this is Google's webpage. So everyone's probably pretty familiar with it. But on the one webpage, all of the types of intellectual property we talked about today are on there. So we have copyright, which is the HTML code, will be protected. So nobody can just take that in full and duplicate it. We have an algorithm. The Google search algorithm is protected by trade secret. There's also a patent for site quality that ranks and classifies sites that's utilized on their page. There's an industrial design, which includes the layout of their page, as well as the button placement. So again, if we cover up that logo, we still know that it's Google's webpage from the way that it looks, or the design features of it. And then we have the logo, which is protected, of course, by trademark. So it is really important that you consider what your plan is for intellectual property really early on. You need to determine what types of protection you'll need in the future, and what's the timeline that you need needed for each type of protection. And then what types of agreements you need to put in place with third parties, so with companies that you work with, as well as making sure that you have employment agreements in place that provide you with a level of protection with your employees. So after you have IP, you need to figure out what you're going to do with it next. If you have your own company, you might decide that you're going to use it yourself. So you're either going to create, manufacture products, you're going to sell them, you're going to brand them, and depending on the types of intellectual property you have and what your commercial advantage is, you might decide any of these routes. Another way to go forward is to assign it. So assigning means that you transfer ownership so that someone else can exploit the rights. So maybe you'll decide that, you know what, I'm not going to have my own company. Instead, I'm just going to sell this to somebody else, and they can make money from it. But of course, you would get money for the sale or the signing of the technology or the product that you've created. Thirdly, you might decide to license it. By licensing it, you retain ownership, so you'll still own the product, but someone else can commercialize it. So as an example, at Memorial, there were a team of researchers that created a product that can generate energy from waves. This technology is now licensed to a startup called C4matics. And then as they make sales, they end up paying royalties back to the university that then goes to the researchers who created it in the first place. So that's what a license agreement does. So you still have the opportunity to benefit from the technology. So that's kind of an overview of all the different types of intellectual property. I know it's a lot of information, but if you want to learn more, if you want to talk about IP in your specific situation, like we're here to provide education on intellectual property, to help you understand how to pitch without disclosing information that might be critical to your company and to your competitive advantage that needs to be protected. We also have access to market reports. So we have access to Frost & Sullivan, which can provide you with market reports that are normally like $4,000 and $5,000 each, and we can give those to you for free. And we provide support, of course, for IP. If you're looking to license technologies from Memorial, we're here to support that, and also to support collaborations and connections with the institution. So if you want to collaborate with Memorial to get a specific piece of work done, we can help you with that, and also help you identify funding that can support moving your technology along in collaboration with the university. So that's everything that I have. If you have any questions, let me know, and either in the chat, or if you want to follow up with me afterwards. I know Allison put my information there in the chat as well. So we can easily have a follow-up conversation if that's preferable for you. But really, the main takeaway is to consider, what is your commercial advantage, and what are you going to do to protect that commercial advantage? And every company is different. Every situation is different. If you're selling a technology, then yeah, you might want to focus more on patents and industrial design. But if you're providing a service, there might be a lot of things that you protect under trade secret. There's actually one other link. I'm going to send it out to everybody. There's a checklist that's available on the Canadian Intellectual Property Office's website. And it's a checklist that you can use within your company to help figure out what types of protection you may need to have. I just sent the link out there. So it talks about, if you have a customer list, what would that be protected under? That would be a trade secret or copyright. If you have specific packaging, then you might want to get protection under an industrial design, or you might get trademark protection for that. If you have a website, you'd have copyright or industrial design. So it kind of helps you filter down through them to figure out what the next step should be for you and for your specific situation. Yeah, so that is a very, very quick overview of all the different types, but let me know if there are any questions.
Well, that's fantastic, Cara. Thank you for that really, wonderful introduction and detail to what people need to know. All the links that you mentioned, by the way, we're going to have those as part of our toolkit on the website that's going to be launched in January for easy access. So it'll bring you to the different government sites, not just to the main one, but it'll break it down per section as well to make it easier to find the information you need. Does anyone have any questions? I don't see any questions here yet. I have one question for you.
Yeah.
I think I mentioned the other day I was watching Dragon's Den, and there was someone who came in with this lovely product that I think would have done really well, but they got tripped up on intellectual property. They had hired a company over in Asia somewhere to develop it and create do the technology side of the idea for them. And when the Dragons started asking about IP, you could tell they hadn't done their homework. And what would you do in a situation like that where you're dealing with someone you're hiring out of country? How do you protect yourself in that type of a situation?
Well, it always means that you need to make sure that you have the right agreements in place. It can be a lot more challenging with dealing with other countries, and that's where I would suggest again that you work with an IP agent on that, on what your strategy should be. But you want to make sure that you have agreements in place and protection in place, and that you're clear on who owns it. So if they're designing this, you'd want to make sure that you own it and that you're just not licensing that technology from them, because otherwise they could be licensing it to 5 other people. So you need to be very, very careful on that. Similarly, I had a meeting the other day with NRC IRAP, and they said that this is a huge tangle for companies that come to them for funding, because a lot of times that IP strategy isn't clear, and the last thing that they want is to put a significant amount of federal government funding into a project, and then somebody else can just knock it off and sell it. And so we put all our country invest in it, and then the protection isn't there to prevent other people from just knocking it off, and then no benefit is retained for Canada. So it is so important to, again, make sure you have agreements in place with everyone that you're dealing with. And even when it comes to your brand, if you're hiring someone for your brand, do you own your brand then? Like, make sure that you have agreements on, someone created a trademark, then you want to file for that trademark. When you're filing it, you need to be able to confirm that you actually own that logo that was created for you. So again, look into it, and that's something that you can, of course, work with a patent or an IP agent on. I am going to send you put another link in the chat there as well for the Canadian Intellectual Property Office website. All the different types of IP that we talked about, there are guides on their site that go through them in detail. So if you're thinking about getting a trademark, you can follow that guide step by step of what you need to do and what considerations you need to have as you go forward with applying for protection.
Absolutely, and those are some of the links that we'll have on the website too when it goes live. Because yeah, it is difficult to navigate through, and there's so much there that's really important. We have a question as well from Phyllis. She said, you've covered a lot of valuable information. Are we able to obtain a copy of the presentation?
Yeah, now I know, Allison, you're doing a recording.
This is being recorded, exactly. So we'll be sharing it out to everyone as well. And it'll be, again, it'll be posted on our YouTube and as well on our website as soon as we get that up and running.
Yeah, and I can send a PDF of the presentation to Allison. I will note though that, as you've probably heard as I was going through it, things change all the time. So it is important to make sure you refer to the most up-to-date information. That's why I always say, like, look at the Canadian Intellectual Property Office website, because although this may be up to date right now, in January, a lot of times there are changes. I mean, there were significant changes of patents last January. And so again, we can send it out, but just be aware that things change all the time. So do make sure you check before you proceed with a certain path.
And one other question, I know we're time is pretty much up here. How can you be certain that you're working with, a trustworthy agent when you're getting a patent?
There are no patent agents in Newfoundland. So to work with if it was me, I would want to make sure I have an agent that has expertise in the area that I'm looking to protect. So as an example, Memorial recently protected a very specific chemistry technology. So I wanted a patent agent that had a PhD in that specific area of chemistry, so that they were very aware of what was novel in that field, and was also a patent agent and also a lawyer. So I'm making sure that I cover off all bases. So there are a few firms in Canada that can provide you with very specific expertise in all different areas. So take a look at who those firms are. There are a few of them. We normally deal with a couple that are based out of Toronto, because again, like I said, there are no options here in Newfoundland for any agents. And again, we're looking for agents with specific expertise in the area that we're looking to protect. So again, if it's engineering, we're going to be probably dealing with someone with a PhD in that specific area that knows more than the person who created it essentially on that area. So they can provide us with an extremely well-written, strong patent that can protect us.
So I guess it's important to pay the extra money and get the person or the firm that's reputable.
Yeah, and I mean there are lots of reputable firms, and again, it depends on the level of expertise that you require. From the university perspective, you were often working with people who have PhDs in that area, so we need to have someone who equivalently can understand the technology that they're creating, but making sure they have expertise. Like if say for example, if I was a patent agent, well, my background is in computer science, I wouldn't do a very good job in writing a chemistry patent, right? So again, it's making sure that you have someone that really can cover off that area. But depending on what you're doing, I mean, again, for trademarks are a lot broader, and there are trademark agents in Newfoundland, there are copyright agents in Newfoundland. But with patents are a lot more specific.
Thank you. Any more questions before we finish off here? I think that that might be it. I'm just going to actually I'm going to share Navigate information as well. If anyone has any questions, they can contact me. I want to say thank you again, Cara, for coming on today and explaining all of this to us. I think a lot of people have a lot of questions, and some people don't even know that there are questions that need to be asked. And this has given a great introduction to the sort of considerations that people need to think about when they're starting a business and when they have ideas that they need to protect. So really appreciate you coming on board today, and look forward to having you back.
No problem. Yeah, and maybe next time it will be in person.
I was about to say the same thing. Hopefully, I mean, with the vaccine coming as fast as it is, hopefully we'll all be able to get together face to face sooner rather than later.
Yeah, that would be excellent. Perfect. Thank you again.
Thank everyone for joining us today. And I'll just mention we have our Entrepreneur Ecosystem Coffee Break coming up as well this Thursday. If you haven't signed up, please do. And that'll be a little last chance to say hi to everybody before the Christmas break. So thank you again, everyone. Have a great day. And we'll be sending out the links as soon as they're ready. Thank you.